Okay, so I will introduce Kimberly now. Kimberly Barnes is a solicitor in the Brisbane office. She is one of my offsiders predominantly, and makes up for a lot of things that I would prefer her to do than I do. So she is invaluable support to me. She's going to take you through wills. So I'll hand over to Kimberly.
All right, hello and welcome to our 12th session in the webinar series in the second module of the estate planning series. First of all, thanks for all coming. This is the first time I've had to talk to a blank screen, but I can normally talk underwater, so we'll see how we go. The focus of today's session is on will drafting and the related issues to be considered in relation to that. Today I plan on discussing the roles of wills, the consequences of a challenge to an estate, and when a person dies intestate. I'll also describe the types of wills and how your client can benefit from professional advice, and we'll also look at some case studies to help illustrate this. Finally, we'll also consider the treatment of superannuation benefits and the best ways to appoint other people to act on your behalf. So a bit of a background of a will is that it describes your personal wishes regarding how you'd like your estate to be dealt with following your death. Your will can provide directions to your executor regarding how you'd like your body to be disposed of following your death, whether this be cremation, burial, and can even include whether you'd like your organs to be donated or your body donated to science. Your will can only deal with assets of your estate, which means they can only deal with assets that you personally own. This means that it does not include assets which are owned in a trust, company-owned assets, superannuation, and assets that you own jointly with another person. It is not likely that your family and friends will be able to accurately guess your testamentary intentions, which is why it's important to ensure you have a current will and estate plan. Also, if you die without a will, then intestacy laws will apply, and the outcome of this will differ in each state. Each of the state and territories have enacted different legislation that identifies the order in which a person's estate will be administered in this case. If you run out of family members in the order dictated by the legislation, your estate will go to the government. A testator is a person who makes a will. The most important feature of a valid will is the testamentary capacity of the testator. There's no single test to test testamentary capacity, although various issues will be factored in, such as whether the person understands the effect of their will, understanding the nature of personally owned property, considering whether a person may make a claim on their estate, and being mentally strong and able to make a sound decision. As we outlined in the first module, a minor, a person being under the age of 18, can make a will, but it must be by court order. Beneficiaries can be persons, trusts, companies, partnerships, or charities that the testator chooses. The testator can choose to allocate specific proportions to each beneficiary. They do not have to be equal proportions under the will. The executor is the person who administers the estate of a deceased person and undertakes all of the administrative and personal tasks of the estate. This could include clearing out their house. Not only do they organise the funeral and pay bills, but they also distribute the deceased's wealth, which means there is a high degree of responsibility on the executor. Testators often state that they'd like two executors to administer their will. If this is the case, the testator usually appoints their spouse or children along with another advisor, such as a lawyer or an accountant, enabling a check and balance from the beneficiaries and the testator's perspective. An executor can charge for their time if they are professionally trained to administer an estate, such as lawyers, and their fees would normally be on an hourly basis and charged straight to the estate, not on the executor personally. If an executor decides that they would not like to act as an executor, they can renounce the role to the alternate executor. If there is no alternate executor, the role will fall into the hands of public trustee, which is often not preferred due to their fee arrangement. The trustee under the will hold the assets and for the benefit of the beneficiaries until the assets can be distributed. This is usually once the executor has completed the administration of the estate. In most circumstances, the trustee and the executor are the one and the same. If a testator dies leaving children who are under 18, then the children will need a guardian to look after them while they are minors, in the case where the spouse has predeceased them. This nomination can be made for in the will, and if a nomination is not made and no one in the family offers to care for the children, the public trustee will be responsible for their care. Obviously, this is an important provision in the will with anyone with a young family. Consideration should also be given to when you appoint parents as guardians as to appointing an alternate guardian if they are too old or no longer around to care for those children. In relation to trusts, the trustees usually nominate a person as appointer or principal of the trust. This is the person who effectively controls the trust. This is a critical role in the trust, and therefore the person who's generally nominated to replace the trustee, as it's generally the person who is nominated to replace the trustee, and required to approve variations of the trust. For this reason, your client should ensure that if they bear this role, they consider who will assume this role on their death, and this should be addressed either by the client's will or through the mechanisms of the trustee. If a potential beneficiary makes a claim on an estate after the assets have been distributed and they are successful, the beneficiaries may be required to reimburse the estate so as to distribute the assets to the claimant. A potential beneficiary must make their claim for maintenance from the estate within 3 to 12 months from the date of grant of probate or letters of administration, depending on jurisdiction. For some states, this is from the date of death, which is the case in Queensland and New South Wales. However, it is possible to reduce this risk of potential claims against the estate if the testator takes the right steps during their lifetime. For example, in nearly all situations, it's preferred for an individual not to own assets in their own name. For example, they can own assets in a trust. This will mean that the asset does not form part of the estate and the claimant cannot take an action on that asset. The testator may choose to take further steps, such as signing an affidavit outlining the reasons for omitting a person from the estate. And extra layers of protection can be secured by couples preparing a binding financial agreement during their lifetime. This can also be referred to as a prenuptial agreement, and it serves to confirm each person's assets and how property will be divided in the event of separation. And this agreement will operate even after the death of each party. This means that the surviving partner's inheritance would be limited to the gift made under that agreement. So you may have heard of the process of seeking probate following the testator's death. This involves the executor presenting what they believe is the testator's final will and other supporting documents to the Supreme Court to request that the will be approved as the last valid will and confirm that the executor has the right to administer this estate. Many financial institutions won't release the deceased funds until probate has been granted. A lot of banks have an $80,000 limit. Also, the grant of probate reduces the opportunity of a challenge by a beneficiary, as the executor can rely on the grant of probate to defend this challenge. This is because the probate acts as an absolute approval for the validity of the will. So if a claimant doesn't have an interest under that will, they could only possibly receive a distribution through a family provision application. It's not compulsory to obtain probate. It can take between 3 to 9 weeks, depending on what jurisdiction you're in. However, some assets can't be dealt with unless probate has been granted. So if we discuss a little bit of the family law court, they do have very wide powers. Divorces are usually heard in the federal magistrates court and will progress to other courts in extreme cases. The decision-making process includes the valuing the net assets, whether this is globally or on an each asset basis, and contribution to the marriage, whether that's financial or non-financial. The rule to remember is that all assets in a person's personal name can be attacked. And where a spouse has complete control over a trust, even this is a discretionary trust, those trust assets might be attacked. So that's when one person would be the sole appointer and sole trustee. They can come under attack then, which is why we usually recommend having 2 people in that position. Where a spouse doesn't have full control of a trust and where the inheritance is clearly left for the benefit of one person only and not their spouse, those trust assets are generally protected. The preferred strategy is to implement a bloodline testamentary trust will with an independent co-trustee to protect the testator's family. Also, inheritances aren't not protected from bankruptcy, which is why it is important to implement suitable asset protection strategies sooner rather than later. This can include gifting all assets to the bloodline testamentary trust rather than beneficiaries in their personal capacity. There have been a number of high cases in the High Court over years which have confirmed that inheritances that are gifted to children via a testamentary trust can be outside of divorce proceedings, as it's often the parent's intention to only provide the gift to their children and not their in-laws. While it might seem obvious to you and I that making a valid will is crucial, it is important to remind clients that there are many issues that can be avoided if they have a will. It can ensure that their wishes are carried out, avoid family conflicts, and it will planning on who will assume the control of each trusting company. What happens if a client doesn't have a will? Well, upon their death, it would start with the family deciding who should make a claim to be the executor of the estate, and then seeking professional advice as to who would inherit the estate and in what proportions. This is assuming that it all goes smoothly and there's no family arguments, but that stress and cost arising from that, if a family made a claim on the estate, could be quite large. It's crucial when we're drafting a person's will that we have a clear understanding regarding the family dynamics and the testator's structure to be able to draft the will correctly. As discussed, in order to make a legally valid will, the minimum requirements are that a testator must be legally capable of making a will. This means that they must be over 18 years of age and have the mental capacity to express their testamentary intentions. If a testator gives away an asset under a will, but then later sells it, then that gift will fail because the testator no longer owns that asset. Whilst there have been cases where video wills and the like have been found to be a legitimate will, the process to have these declared as a last valid will of the person is an expensive venture. This is one of the reasons it's so important to ensure that a will has been drafted correctly to avoid this. Obviously, you can't give away assets that you do not own, and if you try to, the gift will simply fail. That's why we need to deal with the ownership and the control of entities to ensure those gifts go. So this can include, as discussed, items owned in a trust, jointly, and in a company. So we might be wondering how to channel those assets that are owned in a trust or a company through to a beneficiary on the controller's death. So in this example here, the dad is the principal of a trust and that trust owns a boat. Being the principal, the dad has the ultimate control and can replace the trustee of the trust. So if the dad wants to gift the boat to his son, the best way to do that would be to appoint the son as appointer under the will or through the mechanics of the deed. This would mean that once the dad passes away, the control of that trust would go to the son and he would then therefore have control of that boat. In similar light, the dad also owns an investment property in a company in which he owns all the shares of as well. So because the dad doesn't own the investment property, the company does, we need to look at gifting those shares in his will. The dad has decided to leave the property to his daughter and therefore he gifts those shares to the daughter under his will, and this will effectively give her control of that investment property. There are other options available where the structure is more complicated and there are more assets involved, but we will touch on that in future webinars. While a standard will may be suitable in situations, the threat of divorce or insolvency in the next generation means that other options should be considered, and any challenges from other beneficiaries must also be considered when drafting a will. Standard wills are not designed to last a long time after the testator's death. Under a standard will, an estate is directly given to the specified beneficiaries, which is generally the spouse or the children in their personal capacity. A standard will doesn't provide any flexibility in relation to the distribution of income or asset protection. That doesn't mean there aren't any advantages to a standard will, but they are relatively simple, inexpensive, and easy to establish. On the other hand, they do have disadvantages, including that there's no asset protection, taxation flexibility, and each child's share is vulnerable if they become under attack, whether that be by divorce, bankruptcy, or any other way. As you can see on the slide, a standard will generally leaves the whole of the estate to the surviving spouse, with the remaining to be split between their children equally. For these reasons, it's why testators often choose to incorporate a trust into their will. A trust is simply a relationship between the people who are nominated as the trustee, the beneficiaries, and the assets comprising of the trust fund. The trustee is required to deal with the assets vested upon them for the benefit of the beneficiaries. In a standard will, which has a simple trust, a trustee is required to hold the assets for and account to the beneficiaries. However, in a testamentary will trust, which is essentially a discretionary trust, there is usually a range of beneficiaries, for example, the testator's children, grandchildren, and great-grandchildren. The trust can last up for 80 years, and a trustee has the discretion to decide which beneficiaries will receive benefit from the trust, whether that be capital income in nature and when that gift is to be given. This flexibility is one of the greatest strengths of a discretionary trust. If there is some compelling reason that the testamentary trust does need to collapse, it can vest and the property can vest in the individuals and we can close the trust. Depending on the situation, a testamentary trust could be established for each child. The result is ordinarily that the surviving spouse will control each trust upon the other person's death, and then on their death, the relevant child takes control of the respective trust, so once both parents have passed away. Therefore, as each beneficiary entitlement is held on trust, which they generally control, a testamentary trust provides a much greater degree of asset protection for the beneficiaries of the testator's estate. Testamentary trusts are ideal when the testator has significant wealth, or the beneficiaries are minors, disabled professionals who are at risk of being sued, such as doctors, lawyers, and where you are concerned about a person's spouse and wanting to protect that interest for your bloodline. Wills incorporating particular types of trust can be demonstrated to have clear advantages both from a tax planning perspective and from an asset protection point of view. The main advantage is that unlike ordinary trusts, minor beneficiaries can receive income distributions from a testamentary trust which are taxed at an adult income tax rate. Whilst there have been some changes to that recently, it only allows income to be distributed from assets that have been gifted to that will or assets that have been substituted from that. As a result, the drafting of a standard will is not as complex of that as a testamentary trust will. This means that while a standard will may be less expensive, they do not provide those same extensive benefits of a bloodline testamentary trust. Cleary Hall has developed the Bloodline Testamentary Trust Will, which establishes a bloodline trust in a person's will. The essential features of this are that the trust capital can only be distributed to the bloodline, which are typically the testator's mum and dad and children, great-grandchildren, grandchildren. This, of course, can be tailored to meet your specific circumstances, including the inclusion of stepchildren. Now, whilst we always use the example of mum and dad, these can be crafted to suit same-sex couples and any children that they may have, children, couples without children, and single people as well who might just want to benefit their favourite niece or godchild or anybody really. As you can see from this diagram, one trust is established for each child, whereby capital can only be distributed to the relevant child. As you can see in this example, you have 3 bloodline testamentary trusts established upon the death of the mum. At some point in the future, mum and dad's bloodline may run out, for example, when all children have passed away and have not left any children of their own. If this ever happens, where the bloodline of all 3 trusts has run out, the secondary beneficiaries, which are the extended family, will not only be able to receive income, but will be able to access the capital of that trust. The features in a bloodline trust provide greater asset protection than your ordinary discretionary trust by restricting any capital distribution to the bloodline only. No beneficiary can be said to own an interest in the assets of a bloodline trust, it being a form of a discretionary trust, until the trustee actually allocates that interest to them. In a sense, the ownership of the assets is held in suspense until the trustee decides to pay income or capital to a particular beneficiary. As a result, the risk to the assets is minimised when they come under attack. Should a particular beneficiary come under attack, whether it's through divorce or bankruptcy, his or her assets will not be included, which are part of the bloodline trust. Further, a family law court cannot barge through a bloodline trust that is properly set up and properly administered. It is the clear intention of the testator that the assets of the bloodline trust must be available only to the testator's child, but also the testator's grandchildren and great-grandchildren. Under a bloodline trust, the trustee has very wide powers and heavy responsibility, so it's really important to consider who's going to fill that role. So one of the questions is, how can a client ensure that the kids maintain the bloodline will? If they're the sole trustee, you cannot, which is why we often recommend that a co-trustee is appointed. This role is often filled by a person's accountant or lawyer, but their role is generally limited to decisions relating to the winding up of the trust, change of trustee, and distributing the capital of the trust. A trustee is not automatically a beneficiary of a trust, so there is no financial interest. Their role is to preserve the trust for the bloodline. Children will have everyday control of the assets, and the co-trustee will only have control for those specific issues previously raised. Generally, when we prepare a bloodline will, we'll also do a letter of wishes. The letter of wishes is not binding and it is separate to your will, but it is a document that simply provides guidance to your executors and trustees on how you'd like your distributions to be made. While your superannuation benefits cannot be dealt with under your will, a testator can instruct the trustee for their superannuation fund as to who should receive their benefits. This can be done through a nomination. By leaving your superannuation death benefits to your estate is not always the best approach. It may miss out on tax advantages available if you were to leave it to your benefits to your tax dependent. Depending on the drafting of your superannuation fund, your client may be able to make a death benefit nomination, which may be binding or non-binding. The death benefit nomination allows the member to direct their death benefits to particular people or your estate. If you wish to make a death benefit nomination, you must provide it to the trustees of your superannuation fund. The trustee of a superannuation fund must comply with a binding nomination and is not simply the member's general indication as to where they want their distribution to go. Binding nominations are fairly common in retail superannuation funds and self-managed super funds as well. However, nominations that are made through a retail super fund lapse after 3 years. Therefore, once that 3-year period is lapsed, those nominations will no longer be valid. So it's really important to make sure you keep that up. Whereas self-managed super funds often permit nominations to be non-binding or non-lapsing. Sorry, binding and non-lapsing. The question is, does your client want to allow the executor to vary the instructions on the nomination, either with regards to the beneficiary and or the amount? Nominations can only be made to the dependents or the executor of the estate. Under superannuation legislation, a trustee of a superannuation fund can only pay a death benefit to the member's dependents or the executor of the estate. If no one is located, only then can they pay the benefits to another person. Likewise, a member can only nominate people who are categorised as their dependents or their estate to receive the death benefits. The superannuation legislation outlines that a dependent includes the spouse, but not former spouse, or a child of the member, or a person who has a specific type of relationship, which is known as an interdependency relationship with the member before the death. The superannuation legislation states that an interdependency relationship must have been a relationship which was close, where they lived together. At least one of the people in the relationship financially supported and provided domestic support to the other, Also, if two people would ordinarily satisfy all of the criteria for this, apart from a disability preventing it, they will still pass the test. As you can see, the range of potential dependents that a trustee of a superannuation fund is able to distribute to is wide-ranging. And if the testator nominates a dependent to receive their death benefits, significant tax savings for the estate will flow. This is because the death benefit will not be considered assessable income, providing that the beneficiary is a dependent of the deceased member. However, in reverse, the range of beneficiaries that are permitted to treat the death benefit as non-assessable income is narrower than the range that the trustee is able to distribute to. This is because a superannuation fund can distribute to dependents, a child of any age, and someone who is in an interdependency relationship or the executor of the estate, whereas only the following people can treat the benefit as non-assessable income, being a spouse, a child who is under 18, and someone who is in an interdependency relationship, and former spouses. As you can see, the classes of people referred to in the Income Tax Assessment Act is narrower because only children under 18 can treat the benefit as non-assessable income. As the superannuation legislation doesn't permit the trustee to distribute to death benefits to former spouses, this power can be written into any self-managed super fund trust deed so that this can occur. So a power of attorney operates during your lifetime. The main features of a power of attorney are that can you appoint persons to act on your behalf in relation to both medical and/or financial decisions, which include legal, and provides protection of your interests when you're at least able to. While each state and territory have a power of attorney can be restricted to certain dates or events. It can be revoked as long as the person making it has a sound mind. And if it's enduring, it will survive any later mental incapacity. A power of attorney can be convenient if you're out of town, but it can also prevent family disputes when it comes to making medical decisions for yourself when you're unable to do so. Likewise, by ensuring someone else can make decisions on your behalf, it means that your business doesn't have to come to a halt overnight if some event should happen. While each state and territory has a different form of a power of attorney, generally all forms will be accepted throughout Australia, apart from when they need to be relied on in relation to land. If it is intended to buy or sell land in different jurisdictions, it's prudent to execute a power of attorney in each relevant jurisdiction. Oops. In comparison to Queensland, some states require separate documents to deal with legal decisions and medical decisions. In Queensland, you're able to provide both powers in the same document. Similar to a power of attorney, an enduring guardianship permits a person's guardian to make medical and lifestyle decisions on the person's behalf, although this power cannot be extended to making a will, voting, consenting to marriage, and financial decisions. Again, similarly to a power of attorney, an enduring guardianship can be revoked, and each jurisdiction has their own rules in relation to this. So one thing not to forget is to let the executors know that they're nominated for the role. We generally suggest that you let them know that you're considering them for the role to make sure that they are happy to do that. It's also helpful to provide the executor with a summary of the testator's assets and liabilities, which can be stored with the will. Wills should be stored in a secure place, and the executors should be told of this location so that they know where to go in the event that something happens. And your estate plan should be updated every 5 years or when a significant event takes place, or at the very least looked at just to make sure it still reflects your current wishes. So in summary, a will should be prepared to provide clarity, to avoid family arguments and carry out the testator's wishes, and avoid unnecessary legal fees should anything happen. Does anyone have any questions?
Thank you, Kim. If anyone has any questions, please feel free to put them through the chat line now. But if not, thank you again for coming along. Today was a bit quicker than normal, which is better for everyone. Maybe I talk a bit much. I have a question through here. Can wills be stored electronically?
You can store an electronic copy of a will, but in the event that it actually needs to be relied upon, we will need the hard copy. So most law firms will, and we do have one, we have a safe custody facility where we store any original wills.
Yeah, the short answer to that question is no, because you do need the original to be submitted to the Supreme Court. Obviously, in this day and age where everything is stored electronically, copies and the like, if the original does go missing, there are processes you can go through to verify that as being, I guess, a copy of the will. The difficulty with relying on that approach is that it becomes more expensive. That's the bottom line. Is it's it's difficult. Courts are reluctant to give probate without robust examination of the proper will. That's why you'll sometimes hear lawyers say, well, don't put any marks or pins or staples on the document, because the court will inquire as to, well, was there a document that was stapled to the will that might have changed the will in some way. So relying on an electronic will is not best practice. So again, thank you. If there's any more questions, feel free to put them through. We will be back in 2 weeks' time, and we'll be exploring a little bit more about existing trusts and how we deal with existing trusts in our estate plan. So thank you again, and just remember that feedback survey will be out shortly. Thank you.